Prof, I can do mine on the employment one. So basically, I first started with who owns the actual copyright, and the point of departure from Section 21, 1A is that the author owns the copyright. But now, who's the author? Because it's not always that whoever has created this work is considered to be the author. So the act sets out different. I will do this again over a PowerPoint, but the act sets out different types of works and who their authors are. So like a literary, musical, artistic work, then whoever initially created that work. There's things for photographs and sound recordings and all that type of stuff. And then there's also definitions of what is a literary, musical, a cinematographic film, computer program, and everything. And then there are three exceptions to the general rule of the author owning the copyright. And like Genevieve was saying, the first one is where a newspaper or a magazine or a similar proprietor has commissioned an artist to create something for that newspaper, then that proprietor will be the owner of it. The second is when somebody commissions the taking of a photograph or drawing of a portrait or something, that whoever has commissioned that work owns it. And then thirdly is if something is made in the course of employment, that employer owns that copyright. So now there's a difference between an independent contractor and an employer. And I set out we have 3 tests in South Africa to determine what makes someone an independent contractor. The first being the control test, where it looks at does the contractee exercise power over the independent contractor? Can they control their working hours, how the work is done, when the work is done, and all that kind of thing. Second one is the integration test, which looks at to what extent the person is integrated into the organization of another. But in South Africa, we use the dominant impression test, where the courts take into a whole bunch of factors and to decide who is an employer or not. Then I've set out all those factors. And then so the law for an employee is that the employer owns it, and the law for an independent contractor is the artist or the independent contractor actually owns the work. But what usually happens is that there'll be some kind of agreement that regulates what happens when it's an independent contractor situation. And that agreement will say who owns the copyright. But in the absence of having such an agreement, the independent contractor would take the default first ownership rule. And then I think the next important thing to touch on is what is meant by in the course of employment. And what the courts have said is that there's no hard and fast rule, and they didn't want to set concrete factors into what makes something in the course of employment. And rather, the court will look at all of the surrounding circumstances to decide if something was generally made in the course of employment. And what that kind of, after this King versus SA Weather Service case, seems to be is that if the only reason you had created that work was because of your employment, then it is in the scope of your employment. Mm-hmm. But if you would have created it regardless of what job you were doing, then that would be seen as, that would then be protected. Yeah, I think that's just a basic summary of everything.
Great, thank you very much. Perfect presentation. Well done and well understood.